Good morning, Mr. Stevenson.
Good morning, Your Honors. My name is Charles Stevenson. I represent the defendant, Roger Francis. In its simplest and starkest terms, it's our contention that this was not a capital case within the meaning of Chapter 263, Section 6, and that accordingly, Mr. Francis should have been permitted to waive a jury trial. There are, as Your Honors know, having reviewed the briefs, a number of reasons that I put forth in support of that assertion: rules of construction, rules of logic, and perhaps most fundamentally, principles of fairness. It's also our contention that were this court to conclude that its previous constructions of the statute remain apt, that the statute, as this court has interpreted it, is unconstitutional as being both under and over-inclusive and bearing no rational basis in present homicide law in the Commonwealth. It's important, I think, to make the court aware of how significant this fact or this issue was in this case. It has perhaps one of the most tortured histories that this court's ever going to encounter. Mr. Francis was indicted and tried in 1967 in the death of a young woman in Plymouth, or I guess it was Hingham, and convicted of first-degree murder, notwithstanding the fact that there were three experts, all of whom testified that in their view he was paranoid schizophrenic and not criminally responsible. This court affirmed that conviction, but by a vote of 4-2, an unusual split, two judges expressing the opinion that in their view, given the experts' opinions, it was a verdict that was against the weight of evidence. Mr. Francis ended up in Bridgewater State Hospital, then in Medfield State Hospital. He was being treated to a degree almost like a civil commitment, and was getting furloughs and whatnot. The district attorney ultimately objected. He was reincarcerated. In 1989, he filed a successful motion for new trial. It turns out that at the original trial, the judge gave one of those reasonable doubt means, important decisions in your life, like getting married, buying a house, that sort of thing. The district attorney appealed that conviction, or that ruling, and in 1992 it was affirmed. 1994, Mr. Francis pled guilty to second-degree murder, and in a very convoluted set of circumstances that Your Honors will get a flavor for in some of the preliminary transcripts that you have in the present proceeding. Ultimately, in 2000, he withdrew that plea. The case was scheduled for trial.
How did the psychiatric testimony, how was it admitted in evidence? Were all the experts no longer available?
Well, I believe what happened was two of them, it was established, were dead. The third one, I think, was so elderly and was living in Florida that he was functionally unavailable. So it became, and that's why, of course, one of the reasons why, first of all, Mr. Francis, by that point, was white-haired and it was 36 years after the incident, after these original diagnoses.
Out of curiosity, why did he want to withdraw his murder too? He would have been paroled.
Well, that was part of the deal. There was this agreement that he would plead guilty to second-degree murder, that the district attorney would not oppose parole. He'd already been approved for a commutation back in the pre-'89 era, so it seemed like a done deal. But then the parole board said, oh, wait, we made a mistake. He has to be incarcerated in order to reach that conclusion. He'd been bailed in 1989 by Chief Justice, then Justice Wilkins, and so he was on the street and not anxious.
He was out on bail for 13 years, wasn't he?
He was. And so the arrangement had been initially, well, he would plead guilty, he'd see the parole board, he'd be paroled, and if he weren't, he could withdraw the plea. Then when the parole board said, wait, he's got to be incarcerated, it was going to be for a very brief period, literally for the hearing itself. And the district attorney, I think justifiably said, no, we are not going to agree that this stay go forward any further. He should, if the parole board needs him in jail, he ought to be in jail now. Ultimately, the years went by, and I think that, frankly, both sides could be faulted, and certainly Mr. Francis himself, his attorney. But it got to be 2000, and Mr. Francis's mother at that point was 90 years old. He was out on bail. He was taking care of her. It's a very difficult set of circumstances. And as I said, I mean, the equities cut both ways, the facts cut both ways, but here he was in 2003 facing retrial 36 years after the incident. And I think Justice Spina isn't here to quote the case but this court in the year 2001 cited with favor an appeals court case that talked about the fact that it's not unreasonable to think sometimes judges may be more dispassionate judges of the facts than would be a jury. The case is Commonwealth versus Adkinson, and it's cited in, I believe, my reply brief.
Well, he comes on for retrial, and he wants to waive the jury, and the judge says you can't, and we have the trial, and he's convicted of murder one, and he's back in, and his defense was lack of responsibility. Again,
yes. And at this point, recited through a play acting thing where...
With the old testimony?
Exactly.
Yes. Right.
And I'm not going to stand here before your honors and say that there wasn't some evidence that he was sane. There was...
Commonwealth had no expert?
They did. They had a live expert who had seen him recently. And as you'll find out, the defendant had an expert too, but his opinion was not going to be consistent with the 1967. So, I mean, I wouldn't want to present it as being a totally unfair situation. It was not. But, people, the debate really became, do people get well when they're schizophrenic? And Dr. Kelly said, no, they don't. In fact, they get worse and worse and worse and worse. Mr. Francis hasn't gotten worse. He has certainly, it appears.
How old is he now, roughly?
61, 62, something like that. And as the government would point out, some of his period of incarceration, which was 23 years before, 5 years now, or I guess it's only 4 now, has been at state hospitals. But yeah, he's been in jail a very, very long time. In any event, to get to what I'm really anxious to say, it's been 30 years since this court really closely examined the interface between Chapter 278, Section 33E, and the jury waiver statute. And while I invite you to be skeptical and dubious, I would ask you, too, to have an open mind and to consider that it may well be that the decisions of this court back in the 50s and 60s and 30s are no longer applicable here. The statute itself says in a capital case you can't waive a jury. It was enacted in 1926. Capital meant capital in 1926.
Death sentence.
Pardon me?
Death sentence. Exactly.
And I mean, I'm guessing, I never actually researched it, but I assume capital comes from cutting off one's head, that must be the origin. But I point out, too, by the way, that it wasn't limited to murder cases, first degree or otherwise, that for many, many years in this Commonwealth, and of course the history of capital punishment enjoys, if I can use that word.
Mr. Stevenson, you're focusing on the nature of the crime and the punishment. I think very few of us remember what the circumstances were when it first became permissible for a single justice of the Superior Court to sit in a capital case. That was very recent.
I guess I'm going to have to say, Your Honor, that it's so recent, I don't think it's happened yet.
No. To have a single justice presiding.
Oh, as opposed to three judges?
The trial judge.
Trial judge?
Yeah.
Okay.
It used to be only the Supreme Judicial Court, and there were always at least three of them. Then it became the Superior Court, and there were at least three of them. And around this period of time was the first time that a Superior Court judge could preside alone. We forget that.
Well,
and so saying that you've got to have a jury has to be viewed, I think, in the context of not only the nature of the crime, but the nature of what was perceived to be, at the time, a somewhat radical experiment.
Well, and certainly, I mean, before 1926, I think, I can't remember the case off the top of my head, but it was held, well, you know what, you can't waive a jury in any circumstance in Superior Court. And ergo, this statute was promulgated. And then very shortly thereafter, the case is Commonwealth versus Millen. The guy says, hey, you know what? I know I had a capital case. I know I'm facing capital punishment. I wanted to waive my jury, and I wasn't permitted. And this court said, this was this court's reason for upholding the statute against the challenge. The statute in question makes only a reasonable classification in providing that a man's life shall not depend upon the findings of fact made by one man.
Mr. Stevenson, you make an argument, I think, that Rule 25B, in effect, permits a single judge to set it to reduce the verdict, so that, in effect, a person could get a trial before just a judge.
That is one of the...
Did this defendant ever seek to take advantage of Rule 25B?
He did not.
So you could have gotten what, in effect, you're asking for.
Well, I suppose that's true. I mean, I don't know that that can be construed as a waiver of this argument, though.
But you're making the argument that you want a trial before a judge. Then you make the argument that defendants can, in effect, get a trial before a judge by seeking Rule 25B, which
through the back door.
Reduces the verdict. But then this defendant never even tried that route when he could have. Theoretically.
Well, I think that's theoretically true. I mean, I wasn't in the case.
Because the judge who presided over the trial would have most likely denied it based on the substantial evidence that the defendant knew what he was doing at or about the time of the crime.
I think that's entirely possible. And, of course, I can't stand here and say to Your Honors, well, he would have been found not guilty by reason of insanity had he been tried before the court. But I don't suggest that that's in any respect my burden here. As Your Honors will see, and, you know, the arguments are many, Rule 25B being one of them, but as time went on and as Chapter 278-33E was amended, I mean, bear in mind that originally, through the 30s, 40s, and into the 50s, capital meant capital. And I don't have any direct complaint with that. But then, all of a sudden, for Section 33E, capital meant first and second degree convictions. And all of a sudden, this court was saying, well, this is Commonwealth versus O'Brien, we believe that the prohibition on waiver of jury trial in capital cases reflects the same legislative concern with safeguards as does Section 33E. Ergo, we're going to continue to impose those rules that say you can't waive any time you could potentially end up a 33E defendant. But you know what? I point out a number of cases, starting with one in 1803, Commonwealth versus Battis, where the young man comes before the court on his arraignment, says, I'm guilty, and the next day he's executed. Yes, there were, the judge brought him back in the afternoon, are you sure? That is still, were there a death penalty in this Commonwealth, that is still something that could happen today. Why is that? That is because Chapter 277, Section 47 says that you can come in at your arraignment and plead guilty. If you don't, and this is in cases including capital cases, if you don't, a lawyer will be assigned you, and you may plead not guilty, and the case may proceed to trial. Commonwealth versus Bolero 2, if you plead guilty to first-degree murder, you have no Section 33E rights. So, I mean, all of this is driving toward the point that Section 33E can't reasonably be construed as a pretrial definition of what is capital. It's intended to cure the problem that was created when you had to have exceptions, and if you didn't have exceptions, this court was without power to intervene. It's clearly backloaded, and that was its intent. You know, the reasons go on and on and on, but ultimately I would suggest that the interpretations that were given, the spin that was given to the statute back in the 30s.
Mr. Stevenson, let's assume that we accepted your argument. How do we deal with the very first challenge of ineffective assistance of counsel? The lawyer must have been incompetent to persuade his client. No, I didn't persuade. You've got somebody who is charged with the most heinous crime, and he doesn't know. He hasn't seen the play out of the jury and the judge.
Well, Your Honor,
aren't we just going to get that?
You're going to get all sorts of things as the years go by, and certainly that may well happen. And if I were sitting up there or sitting over there, I would say what I said about 10 minutes ago, Commonwealth versus Atkinson. Nor would it be manifestly unreasonable for counsel to believe that an experienced judge would evaluate an alleged sexual assault, but I think something else could be appropriately substituted there, including a murder of a young woman, upon a child more dispassionately than would a jury. And I would also point out that this court has intervened. I cite the cases Commonwealth versus Cox, Commonwealth versus Mutina. Mr. Francis, two of the 6 justices who heard the case, saying, wait a second, you know, juries just don't get it. And sure, the prosecutor says, well, wait, you know, since then we have, or this court has adopted in Seguin the rule that there has to be an individual voir dire. And yes, you know what, maybe that would weed out people. But I just point out to the court, as I did in the brief, that this court has also said, first of all, that there are all sorts of latent biases out there that can be actuated by this process of individual voir dires. And we're not talking about race here. We're talking about the insanity defense. But I think that it's a reasonable inference. So I would suggest that, yes, and you know what, at some point it might be ineffective for someone to encourage his client to waive a jury. But this certainly wasn't that case. I'm not immediately perceiving any set of circumstances that would dramatically prove that fact. And in any event, I would just, to quote His Honor, Judge Graney, perhaps in a different context, but a related one, Commonwealth versus Paulding, which I rely on for a number of principles in this argument. It says right in, and I believe it was Judge Bosford at trial, it says right in the statute, the grade or the degree of murder will be determined by the jury. Commonwealth versus Paulding says, you know what, it says that in the statute, but there are circumstances where it doesn't apply. It was, quote, an anachronism to impose it in all circumstances, and I'm suggesting that it's an anachronism here. There are all sorts of additional arguments that I would make were we to be here all day. They relate to the state and federal constitutions and some evidentiary issues. But I see that my time has waned, and I simply want to thank Your Honors for your attention on Mr. Francis's behalf.
Thank you, Mr. Stevenson. Ms. McKenna?
Good morning, if it please the Court. Gail McKenna, Assistant District Attorney for the Commonwealth. The Constitution is not an anachronism. A defendant has a constitutional right to a jury. A defendant doesn't have a constitutional right to a trial in front of a judge. And that's what my brother is urging here today. This Court has interpreted the statute in question here as meaning that a capital case means one in which someone has been indicted for first-degree murder, and then he's not allowed to waive his jury for very good reasons. The legislature, of course...
What are the reasons? I'm sorry.
I'm sorry, Your Honor?
What are those very good reasons?
That someone is not allowed to waive a jury?
Yeah.
As this Court said in Millen, the life of one man shouldn't be put in the hands of a single person, a single
that's
juror.
That is in the
And that
context
was-
of a death penalty.
The death penalty.
It is, Your Honor, but if we trace the changes in the statute that have been made along through time, and we trace the changes in the statute along time, along with amendments to the statute, along with the way that we interpret statutes, the legislature is aware of the way the Court is interpreting the statute. The legislature has been changing 33E. The way that we interpret it, when the legislature enacts legislation, the Court assumes it's aware of the existing statutes, presumes the legislature is aware of the prior state of the law, is explicated by the decisions of this Court. It's Commonwealth versus Callahan, 440 Mass. 436. It's been cited many times by this Court. So the legislature, in the times that it's changing 33E, is well aware of the way the Court is interpreting 33E.
Would it be possible in this case for us, apart from this jury waiver thing, to use 33E power to reduce this to murder, two, or manslaughter?
Well, I would think it would be inappropriate, Your Honor. This was a heinous murder of a 15-year-old girl who was in the 10th grade. And the passage of time has in no way mitigated the fact that this was...
But you do agree we'd have the authority to do that?
Well, under 33, yes, the statute does give...
Okay, and if we did that, he'd be paroled fairly quickly, particularly if it's manslaughter.
I have no idea what the parole board would do, Your Honor. And frankly, I'm a little disturbed by the fact that so much has gone into about what happened as far as after this contingent plea that the defendant made. I'd had many talks with my brother about things that happened that aren't part of the record here. And the agreement was made that if he was going to bring that up, it would be in a new trial motion. We talked about that again this morning, that it would be appropriately brought up in a new trial motion.
A lot of the information that Mr. Stevenson conveyed is not in the record.
It's not in the record. It's not completely accurate. It's something that I was a part of, and I don't want to start testifying in front of the Court here. If we're going to have hearings on it, bring the new trial motion. We'll have it fully aired out in front of a judge. Factual findings can be made.
Ms. McKenna, did you, I didn't recall in your brief you saying that there were factual errors, and did you? Maybe you did.
There's a single factual error in my brief, and I did bring it. Counsel brought it to my attention.
No, not your errors. Sorry, I didn't recall your pointing out errors of the kind that you've just described in defense counsel's brief. Am I right?
I'm not sure, Your Honor.
You didn't say in your brief that the defense counsel is going beyond the record in describing the case or the history.
But he didn't. I think what she's saying is that he went beyond the record this morning.
This morning, yes.
That isn't in his brief, and it's
Right,
not in his brief. And she's saying that she doesn't want to go beyond the record.
Right. There's no issue brought up in the brief at all concerning the plea that happened, the withdrawal of the plea, and all the circumstances of the defendant not going before the parole board.
So that's not
Okay,
your objection.
okay,
I'm sorry.
okay.
Right,
I
and
misunderstood.
and that's for a very good reason. We had many very honest, forthright conversations about this. I faxed documents to my brother, and the agreement that we made is if this was going to be brought up, it would be brought up in a new trial motion where everything could be
We
aired.
don't have to get into any of this, because none of this is in the record about his
Well,
thinking
I
about
think-
pleading and not pleading because of the parole board. That's not in the record.
Well, I think
before
that's
us.
the driving force behind Judge, and I may be wrong here, behind Judge Graney's feeling that perhaps this would be an appropriate case for 33E to be used. And I really, because of all the comments that were made in my brother's argument, I think that's something that I do have to be forthright about and address immediately with this court. The record is not complete on that, and I would ask the court
So
if
you're,
that-
well, so I'm sorry, I'm really confused. I learned
I'm
all
sorry.
about this case from reading the defendant's brief. So are you saying that the defendant's brief does accurately reflect the record in the case? I mean, that's how I learned all about this. I don't have any independent source for it.
I'm talking about what my brother spoke about this morning, about what happened as far as
But
the...
just to answer Justice Cordy's question, because it'll help me as well,
Sure.
from your point of view, does the defendant's brief accurately reflect what happened, the record?
I would have to reread that portion of his brief, Your Honor. I'm sorry. I'm just...
Okay.
I apologize. I'm talking about what he said this morning.
No,
which-
I understand, but it's
Well,
important
maybe you
for
should
us.
get back to us on this whole, what was just asked and this, whatever you think
that's
is
why I asked-
wrong this morning. Maybe you ought to write us a letter.
Your Honor, as I said, there are matters outside the record
No,
as far
just
as...
focusing on the brief, that's why.
Well,
Sure.
we can tell pretty quickly whether whatever's said in that brief is part of the record. I mean,
Sure.
that's not a big problem.
That's absolutely true. I
I mean, we look
may
at the
say, though,
appendix,
that
we
it's
look at the
incomplete.
transcript, and if it's not in there, then it's not part of the record.
Sure, I may say, though, that it's incomplete. But getting back to the argument before the court here, as time's gone on, this court has interpreted what the word capital case has meant. The legislature is aware of what this court has said when it's interpreted capital case. It had the opportunity over the years to readjust the jury waiver statute. It has not. And as far as the defendant saying that there's a due process or equal protection argument here, there's no fundamental right to hook that onto, so we never get to that part of the analysis.
Do you have a United States Supreme Court case that you cite that says, you know...
The Singer case?
Correct. That, I think that's it. That, you know, saying you can't waive a jury doesn't create a constitutional problem?
Absolutely. It's no complaint in due process that you can't waive a jury.
So if we're going
since-
to do this, according to you, we'd have to invoke the state constitution in some way.
Well, the state constitution also exalts the jury. The jury is one of the fundamental rights that our forefathers died for, is to have a jury trial.
But isn't
not
there an
to have
equal protection
non-jury
argument
trials.
here rather than a due process argument?
No, Your Honor, there's not, because you have to find a fundamental right first to hook that onto. It doesn't exist in the abstract that you may have a due process or fundamental right issue. First, you have to have a fundamental right. One of the cases my brother cites in his reply brief is one involving sexually dangerous persons. Well, of course, there's a liberty interest there. That's why the court does a due process and equal protection analysis, because to begin with, there's a fundamental right. Here, the fundamental right is to a trial by jury. There is no corresponding right to a judge or a bench trial.
But if we've created a right, the right of a defendant to waive a jury trial, but have only limited it to a certain group, doesn't there have to be some rational basis as to why it wasn't extended to another group, or you're saying no because there's no fundamental right to a
No
jury trial?
fundamental
so
right.
Well,
You need the
essentially what you're
fundamental
saying
right
is
first.
anybody can waive a constitutional right, and then the legislature says, no, you can't in these circumstances because of whatever it is.
No, and the bigger problem is that there's no jurisdiction of the Superior Court to try a case of first degree or capital case, as it's been defined by this court, without a jury. So, you know, where does that leave us? And this court has interpreted the statute. The
It
legislature
leaves us
is aware of
trying the
us.
cases, I
It
think.
does, Your Honor.
That may be your strongest argument, Mr. McKenna.
As far as the other arguments my brother makes are concerned, I do want to touch briefly on his closing argument. I think it's important to talk about that. The prosecutor did say in closing, justice delayed is justice denied. I've quoted cases, I've cited cases in my brief that say that essentially that's a factually accurate, neutral statement. One thing that I do want to add is that the defendant emphasized the number of years, in his closing, emphasized the number of years since the crime, 36 years. And he did talk about that what he wanted to impress on the jury was the justice of his position. So it's important here that both sides talked about justice, and no one said that justice particularly belonged to the Commonwealth. It was a neutral statement. It wasn't objected to. In that light, it was not error, or if it was error, it didn't create a substantial likelihood of miscarriage of justice.
Ms. McKenna, I don't want to, I mean, I know that there was a lot of expert evidence at the first trial, and there were two justices, Justices Whittemore and Cutter, who dissented. But it struck me as I was reading this that the fact pattern of what occurred here is one that is really quite familiar in today's world, namely an overbearing, protective older man with a younger woman who casts him off, and he then ends up murdering her. And I don't know whether one views it differently in 2007 than one did in 1967, but it seems to me that we have a much fuller appreciation of what would be broadly called domestic violence, which is not necessarily the product of schizophrenia. I take it that that's part of what is at issue here.
Well, I think the case was tried differently each time. I think that any time that you retry any case at all, the evidence comes in differently. So I don't know how much bearing the first trial really has on the second trial. At the second trial, there was a lot more emphasis on the defendant's activities and how normal all of his activities were, which of course made it much less likely that he was insane only at that very moment when he murdered Mary Alice Pike. And other things were emphasized differently, as is always the case when a case is retried. They're never tried verbatim the same way. But I would agree. I think that domestic violence and domestic violence murders were really something that came to the forefront in the 90s. In the very early 90s is when we started hearing more about stalking, and the legislature started recognizing as crimes stalking, harassment, and so on. What bearing that has on this case, I don't really know, but I know that as far as the insanity defense is concerned, there was much greater emphasis on his ability to act normally in every single thing that he did. Everything. His work, he had a very responsible job. Every single interaction he had with every individual. And we had individuals who were recipient witnesses at the time who were able to come in and talk about how...
At the new trial.
At the new trial, how normal he was and how nobody sensed anything wrong with him, people who were with him that day. And we had his own statements that said that he was angry that he'd been jilted. She wanted to break up with him. Presumably she did. He said that he wanted to have sex with her, that he thought about raping her. Her clothes were ripped. This is an angry man who murdered a young girl. And I would ask...
5 years age difference between them at the time, right?
Yes,
7.
15 and 19.
15 and
19.
15 and 20, I think.
Right. And I would ask on that basis that this is simply a heinous domestic violence type murder, that the conviction be affirmed.
Thank you, Ms.
Thank you
McKenna.
all for your kind attention.